Good afternoon, everyone. My name is Rob Brennan. I am the Chief Legal Officer here at Housing Assistance Corporation, and we are the sponsors of today's Housing to Protect Cape Cod Advocacy Training Series. This is our sixth training series so far this winter and spring, and today we're going to be talking about the Dover Amendment and related zoning protections. We're going to wait just a couple more minutes to give everyone a chance to get in, and then I'll kick it off by introducing our speakers, and we'll get right into today's presentation. So we're just going to give it another 2 minutes, and then we'll get going. Well, it looks like we're almost up to 15 participants, and I don't see anyone else really coming into the waiting room. So let's kick things off. As I mentioned a few minutes ago, again, my name is Rob Brennan, Chief Legal Officer here at Housing Assistance Corporation, and we are today's sponsors of the Housing to Protect Cape Cod Advocacy Training Series, the sixth of our series this winter and spring. And today we're going to be covering the Dover Amendment and other zoning protections. We have with us today three presenters, Margaret Hurley, Assistant Attorney General, Esme Caramello, also a Massachusetts Assistant Attorney General, and Dain, founding partner at Dain Torpy. Margaret serves as Senior Counsel for Housing and Municipal Law for the Office of the Attorney General. For 16 years, Margaret has served as the Chief of the Attorney General's Central Massachusetts Division and the Director of the Municipal Law Unit. She is a member of the Massachusetts Bar Foundation Board of Trustees and the Massachusetts IOLTA Committee. She's also a graduate of Boston College and Boston College Law School, a resident of Grafton, where she served on the Planning Board and Town Administrator Screening Committee. Esme Caramello, also Massachusetts Assistant Attorney General, is Director of the Housing Affordability Unit at the Office of the Attorney General, Andrea Joy Campbell. Before joining the Attorney General's office in July of 2024, Esme was the faculty director of the Harvard Legal Aid Bureau and a clinical professor of law at Harvard Law School, where her teaching and research focused on fair housing, housing stability, and access to justice in housing cases. Dain was a co-founder and president of law firm Dain Torpy, represents real estate owners and developers in dispute litigation. Dan has worked with colleges and universities on the Dover Amendment issues going back to the 1990s, when Boston College was planning a new student center and humanities building. Dan is also the author of a book, A History of Boston. And I'm proud to say that Dan, former colleague of mine, and co-founded the firm together back when it was Brennan, Dain, Luray, Wiest. So we've got, again, a great panel here today. And we want to kick things off with talking about the history of the Dover Amendment. And of course, no better person to field this topic than a published history author himself. So we'll turn it over to Dain to give us background and history of how Dover came about. Dan?
Thanks, Rob. I really appreciate the introduction, and Rob and I have worked together for 25 years, so thrilled to be joining this group and to be introduced by him. So I get to talk on my favorite topic, which is where there's an intersection between law and Boston history. So if you want to know about the Dover Amendment, I'm going to go back maybe a couple centuries with a little bit of quick background. As people probably know, Boston was a Puritan city. Um, People were as Puritanism sort of lost its grip on Boston, it remained a congregational city, Protestant, and there were very few people with other religions in Boston, really all the way up into the mid 19th century. Boston, which had been hanging um, Quakers on Boston Common in the 1600s, was not seen as a hospitable place, particularly for Catholics. That really starts changing with Irish immigration fleeing the potato famine in the late 1840s and into the 1850s. Irish Catholics were moving into sort of the waterfront area, what we think of as the North End and West End and other parts of Boston. That then follows that wave of immigration is followed starting in the late 1880s, mid to late 1880s, with large immigration of Catholics from Southern Europe, particularly Italy, as well as Jews from Eastern Europe. As the new immigrants move into the waterfront, it really pushes the a little bit more established immigrants out into some of the neighborhoods. And so this pattern of migration sort of pushes the established Protestant Yankees who were living in Boston and then into the neighborhoods out into the suburbs. And so you then enter a relatively long period. 1924 is the National Immigration Act, which ends immigration. And so you have a period of Yankees in the suburbs, Catholics in the city of Boston, and this becomes sort of the great political rivalry we see with James Michael Hurley for so long. And part of the history of Boston is this conflict between Irish and the Catholics and Protestants in Boston. Catholics controlling government in Boston and Protestants controlling Yankee Republican Protestants controlling at the state level. And so what starts changing things is World War II, and following World War II, the GI Bill, and you have this period of Catholic soldiers returning from the war, having a little bit of money and education, and looking to move out of what were considered very crowded areas in Boston, and wanting to move into the suburbs. And this created, it was perceived by the Protestant suburbs as a dilemma, because the Catholics were not welcomed in the suburbs in the 1940s, and yet they couldn't just overtly pass a law that said Catholics not allowed. And so there are a number of tools that were used. Some of them had been used a little bit earlier, particularly deed restrictions in terms of who could buy land, which were considered private contracts. But the suburbs realized that there was another tactic, which is it was perceived that Catholics would not move into a community if it did not have a Catholic school or a Catholic church. And so it was sort of a clever solution to keeping Catholics out, which is if you passed a zoning law that said no new churches or new schools could be built within your community, it was believed to pass equal protection scrutiny under the 14th Amendment, because it applied equally to every religion. There was nothing that said, new Protestant schools or Protestant churches could be built, but Catholic ones couldn't. But of course, what was perceived to be clever about it is that there already were Protestant churches, and the Yankee Protestants tended to send their kids to public school, while Catholics, it was thought at the time, mostly wanted to send their kids to parochial schools. And so the use, starting in the 1940s, of zoning laws as a means to keep Catholics out of the suburbs started becoming an issue. And so, to the credit of the General Court, which is what we call the state legislature in Massachusetts, in 1949, they passed a law which said that municipalities cannot use the zoning power to discriminate against religious or educational uses. And this new law gets its first test in court in 1951 when the Attorney General files a lawsuit against the town of Dover, challenging Dover's zoning laws that prohibited new churches and new schools. And the Attorney General wins that suit, and this statute becomes known as the Dover Amendment ever after. And so it was sort of this curious, now codified in Section 3 of the Zoning Act, but this curious provision protecting certain uses that then get expanded to other uses, including agricultural uses, daycare centers, etc. But these protection of certain uses against discrimination through the zoning law has its basis in efforts to keep Catholics out of the Protestant suburbs. So, like so much of Massachusetts and Boston history, what we have today can be explained by certain conflict in our past. And of course, since the first Attorney General versus the town of Dover case in 1951, there's been decades now of development in the courts, as well as refining of the Dover Amendment itself by the General Court. And that leads me to turn it over to Margaret and Esme to tell us more about the development of the law.
And Dan, before Esme and Margaret start, I just want to let folks know that if they have questions, submit them in the chat. We'll have a period at the end where Catherine Clark, my colleague, who's also monitoring this, and I will go through and try to pick out and frame as many questions as we can for Esme, Margaret, and Dan. So again, with that, Esme and Margaret, we'll turn it over to you.
Thank you. I'm going to start, and I think I've just shared my screen, and I'm just going to kick off the, every time you do that, the slideshow button disappears. In 1 second. There we go. So again, thank you so much and for having us and for being here today with us. Like Dan, very, very interested in this topic and happy to be here talking about it. Unlike Dan, I'm not a history scholar, and so I really appreciated that. I knew some of it, but not all of it, and it's just such a fantastic grounding. Both, because the history is still present in how this law is interpreted, but also there's been a lot, as Dan said, a lot of interpretations since then. So the law is no longer limited to that sort of context of religious groups having discord and discriminating against each other in nefarious ways. It's really evolved to be something much broader than that. And so I'm going to walk us through a little bit of what this piece of the Dover Amendment is. So that's why I have the slides. I have the unfortunate position of not being the storyteller, but instead being the person who walks you through the text of the law. So I'm going to do that with slides. The other thing I want to point out, as probably all of you know, the Dover Amendment is Section 3 of the Zoning Act. The Zoning Act, of course, governs zoning, municipal zoning in Massachusetts. And there are many other things in the Dover Amendment than the things that we're going to talk about today. There are provisions about solar energy systems and citing those. There are provisions about childcare facilities, et cetera. We're really going to focus, at least I'll speak for Margaret and myself, on the religious and educational uses of land, and potentially a little bit about the anti-discrimination provision of the Dover Amendment. So those are just paragraphs 2 and 4 of what I think is an 11 or 12 paragraph statute. Okay, so here's the text. This is what it says. The second paragraph of the Dover Amendment, the religious and educational uses paragraph, says that no zoning ordinance or bylaw shall prohibit, regulate, or restrict the use of land or structures for these two purposes, religious purposes and educational purposes, on land that is either owned or leased by either the Commonwealth or a religious group or a nonprofit educational corporation. So it can be either the owner or the lessor or lessee of that land. And of course, the Dover Amendment includes this proviso at the end, provided, however, that the municipality can still impose reasonable regulations on the use as long as they are reasonable and fit into one of these 8 categories. So I'm going to go into each of these provisions of the law in a little bit more detail. There's been a lot of case law, and we're trying to synthesize it a little bit here. Okay, so there are 3 questions I'm going to cover, 3 key questions that come up when someone comes to town or is in town and wants to propose a use and says, my use is covered by the Dover Amendment, therefore it is exempt from certain zoning rules. There are 3 key questions that often come up. The first one is the owner or the lessee authorized? Are they a religious sect or denomination or a nonprofit educational corporation? So are they, and that comes down to, and I'll talk about this in a second, are they authorized to do or carry out a religious or educational use? Second question is, instead of focusing on who the entity is, the second question is about the use itself. Is the primary or dominant purpose of the project that's coming in the provision of a bona fide educationally or the pursuit of a bona fide educationally or religiously significant goal? And then the third question is, okay, assuming that 1 and 2 are true, and the use qualifies as a Dover Amendment use, which of our local zoning regulations can actually be applied to this project under the circumstances? So 1 question at a time. So first, the Dover Amendment is available only where the owner or lessor is a religious sect or denomination or a nonprofit educational corporation. How do we know? Well, this is a very low threshold. If the organization is a nonprofit or that's registered with the state of Massachusetts, Commonwealth of Massachusetts as a nonprofit, it will have articles of organization. And if those have the word education or religion or some word along those lines that includes the use that they're proposing to do, this question is satisfied. So it's a very low bar the courts have held over time for whether the entity is potentially is qualified to carry out a Dover Amendment protected use. So that's the first question, very, very low bar. The second question is where it tends to get more interesting in the conversations. But again, the courts have construed this very, very broadly. So the second question, as a reminder, is whether the primary or dominant purpose of the project is the pursuit of either a bona fide educationally significant goal or a bona fide religiously significant goal. In this context, throughout the law of Massachusetts, the term education is construed very broadly. It's not just in the Dover Amendment context, it's everywhere. The term education means, sure, it can mean a classroom, it can mean a college, it can mean classes, but it can also just mean anything that is, and these are quotes from the case law, the process of developing and training the powers and capabilities of human beings and preparing persons for activity and usefulness in life. So when you see programs that are really helping people get back on their feet, figure out how to interact in a healthy way with others, figure out how to stabilize and basically how to stabilize their lives. All of those courts have held to be covered by the Dover Amendment's concept of education. So this might be substance abuse treatment programs. It might be residential reentry programs. It might be congregate housing for people with developmental disabilities, right? It might be a homelessness residential stabilization program for families experiencing homelessness. There's just really a broad range of things that have been held to have as their primary dominant purpose the pursuit of an educationally significant goal. Religion, also very broad. And the other thing about religion is that religion is very subjective. In America in 2025, it's probably a dangerous game to start getting into whether somebody's religion is, whether somebody says this is a religious goal for us. I'll give you an example that the Supreme Judicial Court heard, in which a religious camp, an evangelical Christian religious camp, wanted to build an RV park. The RV park was not where the religious activity was occurring, but the RV park was found to have a religiously significant goal because it would encourage people to come to the camp. People might go to the camp and come back and have spiritual conversations while they're camping together, etc. So that was really enough to for the court to hold that was Dover protected use. And as just illustrated by the example about the RV park at the religious camp, education and religion has to be the primary purpose, but it does not have to be the only purpose. And so really, if a program is working to develop and train the powers and capabilities of human beings, teaching life skills, etc., if that's what it's there for, the fact that people are living there, the fact that people are parking their RVs there, the fact that they're parking their cars there, etc., is not going to be, doesn't render it any less protected by the Dover Amendment. So that's question number 2. Question number 3 is, okay, let's say this is a Dover protected project. Now what? Does that mean that it's over? And no, not it's over, but does that mean that the question of which regulations should apply to this project is answered? It does not. It brings you then to the question of which regulations do actually apply to this project. So when we're talking about zoning regulations, and specifically zoning regulations, because again, the Dover Amendment is in the Zoning Act, it is a zoning exemption. So when you're looking at your local zoning regulations, if you've got if a municipality has an existing zoning rule that would otherwise be applicable to the project, it might still apply to a Dover Amendment use, but only if 2 things are true. 1, it has to be in one of the 8 categories that the statute identifies as permissible areas of regulation. And these they're spelled out in the statute, and I've listed them here for ease. If a municipality has a zoning rule that is not in one of these 8, has a zoning rule that is not in one of these 8 categories, it cannot be applied to a Dover Amendment use. In addition, for the regulations that fall into one of these 8 categories, and are otherwise applicable, would otherwise be applicable to the project if it was not a Dover project, it might the regulation still has to be reasonable. And again, the word reasonable is in the statute. What does reasonable mean? Who decides? How do you figure that out? So over time, courts have really thought about this, and the test is whether the regulation will make it impossible or really impractical to operate the use. Because again, these are protected uses. The purpose of the Dover Amendment is to allow the use to go forward, despite local zoning. So the use has to remain possible once you've applied the regulation. And the regulation cannot excessively burden the use unless it appreciably advances a legitimate municipal zoning goal. So in other words, if there is a local regulation that is really going to be burdensome, but it's not going to stop the use from happening, it's not going to be infeasible, it might still be reasonable so long as it is appreciably advancing a legitimate municipal zoning goal. There is a balancing test, but you only get to the balancing test if it's really possible for the project to go forward with the regulation applied to it. So those are 3 cases, and as I said, I just have two more little bits that I want to share. So as I said, Dover is a zoning exemption. The test as to the 8 categories and the reasonableness applies to zoning rules. There are other laws in this world, and the Dover Amendment does not protect a use against all laws. So there will be other sort of state, environmental laws, for example, that a Dover protected use will still need to comply with. Okay, so before I turn this over to my wonderful colleague, Margaret, I would like to highlight just another issue that sometimes intersects with Dover Amendment, uses, or with, I'm sorry, with religious and educational uses under the Dover Amendment. And that is the question of housing for, well, the question of the anti-discrimination laws. So there are two anti-discrimination laws that can often intersect with a proposal under the Dover Amendment. One is just the Federal Fair Housing Act. The Federal Fair Housing Act applies to zoning and zoning decisions, and it makes it unlawful to, among other things, makes it unlawful to discriminate against if it is a housing, like if it is a residential project, people are going to be living there and as their residents. It doesn't have to be permanent. It could be a 12-month program or 16-month program or something shorter than that. So if it's a residential program, it's unlawful to discriminate against it based on who will be living there, if the characteristics of the people who will be living there are protected under the Fair Housing Act. Race, ethnicity, having children is local, but yeah, disability status, right? So it is, in addition to the protections offered by the religious and educational use exemption, the Fair Housing Act is another limitation on the kinds of local opposition to certain uses that is out there. The other is right there in the Dover Amendment. So in paragraph 4 of the Dover Amendment, the legislature of Massachusetts has made it unlawful to discriminate against projects for people with disabilities. And in particular, it's unlawful to treat congregate living arrangements for people with disabilities differently than families or than a project would be treated for a family or a similarly sized group of unrelated people. Sorry, that's the statutory language. I didn't make up that verbiage, but that's the concept. So if you know. So but it is a, so you have to be careful if you're a municipality, you have to be careful if you're you're trying to establish one of these programs, you have this backing of both federal and state law to avoid discrimination. So I will now turn it over to Margaret.
Thank you, Esme. That was wonderful. I have to follow two professors here, which is difficult, but I will do my best. And I thought I'd turn the conversation a little bit to focus on the process and how the Attorney General's office can assist with project applicants and assist municipalities with all these questions that come up with some of these applications. So what does this all mean on the ground? Obviously, applicants will most likely have their own counsel throughout the application process. And it's very important that in our work, we recognize that relationship and we stay in our lane. We're very cognizant that applicant has their own counsel and we're just trying to see what we can do to assist, again, answering questions or assist kind of smoothing the process as much as we can. And why is that? That is because, as Dan referenced, the initial case that established the name of this Dover Amendment was brought by the Attorney General. And in that case, and in many other cases since then, the Attorney General's interest in making sure that state housing laws are correctly administered at the local level was reinforced. And with this current housing crisis that we are in, that public interest is all the more evident to everyone. So we're trying to use the tools of the office however we can to make sure that the Dover Amendment is applied the right way and to serve as a resource, again, for applicants and for municipalities. I'd like to just pause here briefly to describe what a departure this is from our past practice. Historically, the office would normally only get involved with these types of legal questions when there was an appellate level case, and the issue of the application of the Dover Amendment was present, and perhaps the court requested amicus or friend of the court briefs on the issue. And that would be the stage at the very end of a process where the office would potentially file a friend of the court brief. An example of that is the brief that we filed in the Tracer Lane Realty versus City of Waltham case. The decision was issued in 2022. And there, the Supreme Judicial Court affirmed the Dover Amendment protections for solar facilities. It's a very helpful decision, I think, because I think our brief had an impact, and the court discussed the history of the Dover Amendment and the importance of the Dover Amendment. But again, that involvement by our office was at the very end of the process. And now we are taking a different approach, and potentially in the right circumstances, getting involved much earlier in the process. So I thought a hypothetical might illustrate the kinds of things that we might do. So we have an applicant. We will call the applicant Alpha, and Alpha has found a large home in a residential district in the city of Zed. I'm trying to keep away from any real case here, hence my hypothetical. Alpha intends to purchase the property to use it for transitional supportive housing. The structure needs only interior renovations, but Alpha needs a building permit. The City of Zed's zoning ordinance does not allow communal housing in the district where this house is located. So first step, before purchase, Alpha likely checks in with the building commissioner to confirm that this is an educational use protected by the Dover Amendment. Hopefully they get a letter, for example, from the building commissioner that yes, this is a protected use, and they go on with the purchase. But hypothetically, when Alpha applies for a building permit to do the necessary renovations, things start to go a little south. There are delays in getting a response to the application for a building permit, and the building commissioner might make some comments that seem to indicate that he hasn't received any guidance yet from the city solicitor's office. And this is a stage where if the applicant and council contact us and agree that, you know, kind of involvement by our office at this stage might be helpful, we can pick up the phone and talk with the city solicitor's office. Often the city solicitor's office isn't even aware, they haven't been brought in to the process. And they're not aware of this Dover, potentially Dover protected application. And so we can find out if they've been involved, have they provided an opinion, and that usually results in the city solicitor's office becoming involved after that, if they haven't yet been. So say, for example, communications from Alpha's council and communication between our office and the city solicitor's office happens, and the building commissioner issues the building permit. Yes, this is a Dover protected educational use, so the building permit issues, but the building commissioner determines that Alpha must comply with all requirements in the City of Zed zoning ordinance, including the parking requirements. And because the city's zoning ordinance doesn't specify a parking requirement for communal housing, the building commissioners, as they do, look to the zoning ordinance for the most closely equivalent use category, and decides that the parking requirement that must be applied is the requirement for multifamily dwellings. And unfortunately, Alpha cannot meet these parking requirements because of the physical layout of the site. it is physically impossible to add the number of parking spaces that the ordinance would require and have this use be an active or possible use. So Alpha and its council will now need to try to convince the building commissioner that it's not reasonable for the city of Zed to apply its multifamily dwelling parking requirements to this Dover protected use because the site cannot physically accommodate the required number of spaces. So the parking requirement would nullify Alpha's use of the premises, and perhaps likely the residents in this transitional supportive housing don't own cars at a level that you would normally see with a multifamily dwelling. So here again, we can assist with more communication. And I'll stop here to say, Esme has done a wonderful job, and we're in the process of finalizing it, a guidance document that we hope everyone can use, both applicants and municipalities, to answer some of these questions. But stay with communication and perhaps sharing the Dover guidance. The building commissioner still holds firm. The next step that happens in this hypothetical is the neighbor's appeal to the ZBA to overturn the issuance of the building permit. And Alpha then also needs to argue on appeal that the inclusion of the parking requirements for multifamily dwellings is unreasonable as applied to this Dover protected use. And then we get into a situation where obviously there are residents who have concerns. We have a public process. We can assist again with Dover guidance and communication and answering questions. And if there's a further appeal of that ZBA decision, say the ZBA upholds the building commissioner's determination on both counts, yes, the use is Dover protected, but yes, they need to comply with the multifamily parking, then there will be likely an appeal to the Superior Court or the Land Court. And at that stage, we can then do an amicus brief in the trial court. So that is just kind of an illustration of the change in our approach, getting involved earlier in the process, taking advantage of relationships that we built over time with municipal council, and seeing what we can do to, again, smooth out and assist with the process. And with that, I'll turn it over to Dan.
Great. And just before Dan starts, Margaret, I just want to, having witnessed firsthand, the impact and the benefit for municipalities, and for applicants of your office and Attorney General Campbell's involvement at this, at the local level. I want to thank Attorney General Campbell and underscore for everyone who's on the Zoom how impactful and effective and helping to clarify misconceptions and giving a roadmap to municipal officials and zoning board members that is incredibly impactful, and I think saves a lot of time and a lot of potential angst, and really brings clarity to the process. So thank you for that. And now just getting into from a practitioner standpoint, Dan represents property owners and users, and has been involved in this at not only at the local level but trial and appellate as well. So Dan, can you give us an overview of what this looks like from a project proponent's perspective, practical tips on presenting a Dover use, and maybe mistakes that you see folks often make, but give us that practitioner's perspective on this.
Yeah, no, thanks, Rob. And I thought Margaret's presentation is a great lead-in because it demonstrates sort of how complex these matters are, and that it's sort of, I've never had a case involving the Dover Amendment where it was just a simple answer and everyone knew exactly what the answer was. Those aren't ones that any of us are gonna are gonna see, because it's just it's just a rare case where there's a simple application of the Dover Amendment and everyone knows what the correct answer is. And so the reality is when I represent um, educational users and religious uses who are raising questions about uses that may or may not get the protection of the Dover Amendment, as well as if they're introducing new or expanded structures and how reasonable dimensional regulations would apply to those. How it's really should be thought of as a collaborative process. That my practice is litigation, and so there can be an attitude of, well, we have Dover protection, we get to do whatever we want. Um, and the reality is it's a lot better to get sort of the neighbors on board and the municipality on board, and get an approved project. And even if some neighbors are opposed, it's better to be defending against an appeal brought by neighbors against an approval of a project, than it is to be the applicant and you're challenging a municipal denial of a project. One lesson I learned was there was a local college who sent out an RFP for law firms to apply to represent it in a proposed. They wanted to use excess land on their campus for over 55 housing, and so I went and did a pitch to them, and I said, um, even though there's an argument that the over 55 housing, if you follow the LaSalle College model, would get Dover protection, you should definitely, work with the local municipality and how you plan this, and what the dimensions are going to be, and get the neighbors on board. And then I found out that they did not hire me, and that the feedback we got was another law firm told them that because they were Dover protected, they really could do whatever they wanted. And so I was sort of disappointed I didn't get it, and then watched with some schadenfreude, I guess, when their proposal was shot down by the local municipality. They appealed to the courts. It went all the way up through the courts, and they lost on appeal, and they never ended up building their project. So um, you have to be cautious of sort of arrogance by the user as to how far the Dover Amendment can go. So there are some aspects of it that are pretty broad and powerful, and others that are less so in terms of the practicalities. So one is the Dover protection goes to the purpose, which in a lot of ways is fairly broad. We've seen, Rob and I recently dealt with a municipality that was trying to sort of count what the elements were of a proposal that were educational in nature versus not educational in nature. And they kind of had a scorecard. Well, this element might be educational, but these three elements really aren't educational. And so we added up more non-educational elements. And therefore, we think it's less about education and more about a different type of use. And they were really missing the point, which is, well, what's the purpose of what's being done? And if the purpose is educational, it's supposed to get Dover protection. And the use should be protected if the overall purpose is educational or religious, even if the sort of scorecard may say, well, these elements really don't relate to education. And so you see this with the courts being really troubled by municipal regulation of the programming. And so going back, I think, to 1974, there's a case, Bible Speaks versus the town of Lenox, Massachusetts. Bible Speaks was a religious school out in Lenox, Mass, and they wanted to build a softball diamond with field lights and a snack bar on their campus. And so Lenox said no to the field lights and the snack bar. And so the question was, can field lights and a snack bar be educational and religious in nature? And the municipality argued, well, of course not. The snack bars and field lights aren't educational or religious. And the court said, I think it was an appeals court decision, said it's not the role of the courts or municipalities to engage in campus planning for the user, and that if being able to provide recreational activity is part of supporting the overall educational and religious mission of the religious school, then we're not going to second guess that as part of sort of their purpose. And so that did get Dover protection. We saw this in the Mormon Temple case, which went up to the Supreme Judicial Court in Belmont, where the question was whether or not the height of the steeple was protected. Belmont wanted to apply dimensional height regulations to the height of the steeple, and the land court engaged in this process of analyzing Mormon doctrine to determine whether or not the height of a steeple advances the Mormon religion or not. And the SJC said, you know, what are you doing, land court? You really shouldn't be stepping into second guessing or evaluating religious, you know, doctrine. If the religion says that it's important to have a steeple of certain dimension, we really shouldn't be second guessing that. You know, similarly in the Tracer Lane case, where that was providing, if I recall, providing housing for the employees of a religious camp, and the court said that while the housing in and of itself may not be religious, providing housing for your employees is necessary to allow the activity to proceed. And so we're not going to try to parse these different elements. And so to that extent, you see the courts, you know, embracing a relatively broad view. But at the same time, these uses are subject to scrutiny. And so, as I mentioned, there was the case that I had, I won't name the college, but where they had this over 55 housing that had very little related to educational use. And the court said, well, that's not protected. You know, and similarly with the reasonable dimensional regulations, while the SJC in the Mormon Temple case said we're not going to second guess the judgment about the height of a steeple being religious, as long as the dimensional regulations don't prohibit or, you know, overly burden the use, they are subject to reasonable dimensional regulations. In a case that I had, Boston College, we argued that the application of 3 stories and 36 feet to a student center was not reasonable, and the court agreed with us. We argued that, you know, in a student center you have a cafeteria, and if you have 12-foot height limitations on the cafeteria, it's going to feel like a bowling alley, and the court agreed. But that was, you know, we had to have expert witnesses to demonstrate that, you know, how cafeterias are designed and student center needs, and how applying essentially single family dimensional regulations to a student center really discriminates against the use. But it wasn't a slam dunk case, and it took, you know, we ended up litigating the case for 7 years before we ultimately won in the appeals court. And so a lot of certainly these smaller users, you know, can't afford 7 years of litigation. Boston College is really the exception. So the practical advice that I'm trying to give here is, while the Dover Amendment is powerful and provides a lot of protection, it's not a magic wand which just gets everyone to say, oh, of course you can do whatever you want. And much better to come in with a presentation about your program, what its impact will be on the community, why it fits in, why there's a need, and try to work with the municipality and listen to the neighborhood concerns and try to get something that people feel good about. And the more you can sort of win the political and social battle over what the proposal is, you know, and you narrow down what the issues of dispute are, the better chance you're going to get to have a project go forward.
Great. Dan, that is excellent. I knew this hour was going to fly by, and we have a lot of really good questions in the chat. So I'm going to start trying to pick some of these out. And you know, if Dan, Esme, and Margaret, if you can help with succinct answers, we'll try to get through as many as we can. But apologies, I know that we won't be able to get through all of them. Dan, I'm going to start off with one. You know, this is another kind of vague concept under Massachusetts zoning, but the notion of site plan review and, you know, a Dover exempt use, you know, being subject to site plan review. What can you say about how, you know, the limits and those 8 elements that Esme referenced, how does that play out when it comes, you know, in terms of a town looking at a Dover exempt use and looking to subject it to site plan review?
You know, that's a super big question. some of the thoughts on the application of site plan review to Dover protected uses, I think, echo from just regular discussions of the extent to which as of right uses can be subject to site plan review. So Dover protected uses, once you get past that it's Dover protected, can never be subject to discretionary review by the municipality as to zoning, right? So to the extent that site plan review ends up being sort of a discretionary, we want to say yes or no to your project through the guise of site plan review, then the site plan review would not be permissible, right? But that's generally true of as of right site plan review, that site plan review essentially cannot be denied except under extremely limited circumstances. And instead, site plan review is meant to look at the impacts from a proposed project and to come up with reasonable conditions that would mitigate those impacts. To the extent that you do those and the reasonable mitigation are related to the dimensions of the project, and they don't end up discriminating against the use, in general, you can go through a limited site plan review process as not inconsistent with Dover Amendment.
Great, thank you. Margaret or Esme, one of the questions was the intersection or overlap between the Dover Amendment and the Religious Land Use and Institutionalized Persons Act and the protections afforded under that federal legislation.
Yes, so as Esme said, there are in many applications, many potential state or federal protections that might apply. And RLUIPA, as I call it, is one of those. Obviously, that would likely, that would only involve a religious use. So there might be situations where RLUIPA would apply and the religious use protections of the Dover Amendment would apply. There's nothing that requires that you pick and choose if they're both applicable, for example, to your factual scenario. And that again really does highlight kind of importance of having great counsel such as Dan or others, and who are familiar and will be using all available tools for the potential application to your project.
Great. And we have a few hypotheticals in the comments as well. And none of these hypotheticals appear to be tied to any particular town or project. So let me throw some of them out. Could an offsite dormitory or rental apartment building, which houses students, or I guess for that question, faculty as well, for an educational institution, qualify for Dover protection? Again, with it being perhaps offsite of where an educational campus might be located.
Yeah, I mean, I think if it's owned or leased by the educational institution, then it would be, and the housing is being provided for students or faculty for the purpose of attending the school, then in general, I think it's thought that would get Dover protection. If it's just a private housing that happens to be students that are living in it, that's not owned or leased by the institution, then I think they would not be Dover protection.
Okay. You talked, Esme, about other local bylaws or applications, and Jocelyn Murphy asked a question of how the Dover Amendment intersects with general bylaws such as a town's demolition delay or a tree preservation bylaw. Could you speak to that?
Yeah, I'll let Margaret, as our municipal law expert, handle that one.
Great.
Yes, and this is tricky because, as Esme said, the Dover protections are in the Zoning Act. They are a protection for use, and there's no in the statute no reference to the application of other general bylaws. But demo delay now, many communities, it's up to 2 years, and tree preservation bylaws, that's less, I think, Well, I was going to say less impactful to a potential project, but I could see where, you know, in certain situations it might amount to nullifying the project. So with both of those, I think, again, this speaks to Dan's comments about working with the municipality, educating the municipality, and winning over hearts and minds to the project, and how these bylaws might impact the project, and seek, you know, a waiver or other relief within the construct of the town's bylaw process. I think using the Dover analysis is helpful too. You know, if they can't do it under zoning to nullify a use, they shouldn't be able to, and I say they shouldn't, the municipality, shouldn't be able to use other general bylaws that would accomplish the same results. So that's the best kind of way I would approach it. I don't know if Esme or Dan, you have other thoughts there.
Right, Esme?
Well, I guess let me throw out just another, and we'll this one more question that was in, and this was with regard to, you know, applicable requirements. In this case, let's say, you know, parking requirements. Could a local board say, okay, the use is exempt, but you need to shrink the size of the use in local parking requirement? So yes, you know, housing, faculty or students, but fewer of them so that parking minimums can be met on site. Is that an approach that would fly under Dover?
If the use is allowed, if it's a protected use, and they're just saying we want fewer students or fewer participants in the you know, in the religious services, then that's a regulation of the use that's not allowed. And if they're saying, you know, we won't approve without a reduction, then that's running afoul of no discretionary review over Dover protected uses. So, you know, as the hypothetical is given, the answer would be no. But parking is something that can be reasonably regulated. So, you know, that's one in particular where courts seem to be most forgiving of municipal regulation is on parking requirements.
Thank you.
And Rob, I know
yes.
this question didn't come up in your questioning. We only have a minute left, but somebody had asked about ADUs, and I did want to highlight, just because it's so new,
Yeah.
whether there was any overlap with ADUs. And one thing I wanted to highlight is that the UHLC has issued regulations that interpret the statute that makes ADUs, accessory dwelling units, now an as of right use. And in interpreting the statute, the law on accessory dwelling units is embedded into Section 3. It is a Dover, ADUs are now a Dover Amendment use. And accordingly, EOHLC in their regulations has made clear that the reasonableness test that I talked about for religious and educational uses is also applicable to the kinds of regulations that municipalities will apply to accessory dwelling units. So being familiar with that, sort of, does it make it impossible to build this, to use this for the way, for, you know, can you carry out your protected use? Is this essentially a use denial, or are you just trying to put reasonable regulations on it? That very same test is going to be true in the ADU context as well.
Thank you so much for that. And Margaret and Esme, I wanted to ask, you know, we've had 60 participants almost through the entire time. I think folks are now just starting to drop off. But you know, the information that you filed for the Dennis Zoning Board in the matter that we were involved in, I know obviously it's been submitted, it's a public record. Is that something that we could share, you know, with the folks who participated, so they could see again, you know, how your work product can be helpful, you know, for a board, community, and applicants, and I so if you're okay, we'd love to be able to share that with everyone.
Certainly. And also we will send to you and Catherine our guidance. We're really hoping it comes out at the end of this month or beginning of next. And we hope that that will answer a lot of questions and be a great resource as municipalities, applicants, potential applicants, neighbors, try to figure out what the Dover Amendment means and don't want to read all the cases like we did.
Right.
This is for you.
Well, thank you, and I've also just shared in the chat a link to Dan's book, A History of Boston. It really is a fantastic book. You can find it in your local bookstores. Support them. It's also, I know, available online. But really an incredible work, and I'm proud to say that Dan has been a friend and colleague for many years. This is incredible. We also want to let folks know that we have an additional event that we're going to be doing, and this is with Housing to Protect Cape Cod and Cape Cod Young Professionals on April 24th from 5:30 to 7. That's going to be in person at the Cape Cod Community College and also by Zoom. The registration is in the link, and it's the kind of the subtitle here is reasons to be hopeful. A lot of tools have been put on the table through the Affordable Homes Act. Have advocates like the Attorney General's office working on issues like Dover and others, and really it's to highlight the bright spots and the progress that's on the horizon. So with that, again, I want to thank our panel, Dan, Esme, Margaret. Thank you to everyone who attended. Recording of this session will be available, and we'll be sending out an email to everyone who registered that includes the brief that was filed by the Attorney General's office with the Dennis Zoning Board. So until next time, thank you very much. We need all of you. We're in this together, and we thank you for being here and participating and going back to your municipalities and working to promote housing on Cape Cod. Thank you very much.